Hi, this is attorney Joe McPeak with Virtuoso criminal and DUI lawyers. Today I want to talk about the issue of refusals in the defense of a DUI case. As you may know from your own research or maybe personal experience, whenever somebody is arrested for DUI, almost all the time they're told that they have to give some sort of test to determine how much alcohol is in their blood. A test of breath, blood, or in some instances a urine test if that's the only one available for the situation. The refusal penalty is outlined largely in California Vehicle Code section 23612, which lays out what counts as a refusal and how the DMV goes about establishing whether you have refused a test. What you need to know about refusals is that your penalties for a DUI could become more severe if you are found to have quote-unquote refused a chemical test during your investigation. And this can have a lot of really complicated penalties. So in this video, I'm going to cover 1, what is a refusal? 2, what are the consequences for a refusal? And 3, who gets to decide if your case is considered a refusal if you're arrested for DUI? So let's start with the basics. California's implied consent law says that when you get your driver's license, you've implicitly agreed that the officers may test you for your BAC content when you're under lawful arrest for DUI. This implied consent is triggered when you are under arrest for DUI. So I want to make a distinction here. Some people might know that in the course of a DUI arrest, you might be given a breathalyzer before you're actually arrested. That's often called the preliminary alcohol screening test, or a PAS. That pre-arrest test is not what triggers the refusal penalty that I'm talking about in this video. Whether your case is a refusal has nothing to do with whether they ended up getting a sample anyway. In order to prove a refusal, the DMV has to be convinced that 1, you're under arrest for DUI, 2, that after you're arrested, the officer properly admonishes you, and number 3, after you are so admonished, you refuse to or fail to complete a required test. In many cases, the first issue is not really contested. By virtue of coming to us to represent you, you probably have been arrested for DUI. But the second issue, the admonition, is quite contentious often. Sometimes it turns out the police have not properly admonished you that you have to give a sample of your BAC or drug content if they suspect drugs. And if you don't, that you can suffer a suspension based on that refusal only. This whole thing is what they call the admonition. The officer has to admonish you properly for it to be considered a righteous refusal. A driver could be very physically and verbally disruptive, but if they're not properly admonished, then it might not be a refusal. Unless, however, the situation is that the driver isn't giving the officer the chance to admonish them. Those situations might be considered refusal by disruptive conduct. And there are other types of refusals. There's also refusal by silence. In some situations, prolonged silence could actually be considered a refusal because the driver is not actively consenting. And then there are really quizzical situations where the defendant might initially say no and then change their mind immediately thereafter. Technically speaking, that could be considered a refusal. The courts have held that. So this can be a very tricky and complicated issue depending on your case, and it requires good research and good advocacy in order to prevent the refusal penalty from coming down. As I cannot stress enough, only the DMV gets to decide whether your case is a refusal and whether you suffer the penalties of a refusal suspension. The case could be dismissed in criminal court, the prosecutor could reject it for filing, and a jury could come out and say not guilty. It doesn't matter. The DMV would still have jurisdiction, exclusive jurisdiction actually, to determine whether your case is a refusal. In many situations when a jury comes out and says we think somebody's not guilty of DUI, that information handcuffs the DMV and forces them to not suspend your license. Not so in cases of refusal. Only the DMV gets to decide that. So the takeaway is this. If you're arrested for DUI, you need to be cautious not only of any possible license suspension, but whether your suspension might be upgraded to a refusal suspension, which is much more harsh. In order to prevent that, you need to make sure that you have good representation, not just in criminal court, but also at the DMV. Because again, they're the only ones who are going to decide whether your case is a quote-unquote refusal. And finally, what counts as a refusal can often take many interesting and counterintuitive forms. And it's really important that you or your attorney know the law properly when you're litigating a DMV refusal hearing, because you don't want to end up getting deprived of your right to drive for a prolonged period of time following a DUI arrest. It really does take a lot of strange forms, the refusal, in some ways that may even contradict common sense. But the law does say all these things, and that's why you need to be properly prepared to litigate these issues when you have your DMV refusal hearing. Feel free to give us a call anytime for a free consultation at 1-8336-NO-JAIL. And also feel free to check out our YouTube and Instagram sites.